come to the council?
Sure. Whenever we're ready and the judge is ready, I guess.
Okay, thank you. We'll have the judge so everyone knows the period by thing.
Good morning, Your Honor. My name is Monica. I'm the courtroom clerk here in Deschutes County, and I just wanted to make sure that you can hear us.
Yes, we can hear you. Can you hear me?
Yep, we can hear you just fine.
Very well. Are the parties ready to go?
Yes, we do have all parties here in person.
Sir, go ahead and take a seat there, please. And I want to ask Deschutes, are we in the record?
Yes, we are, Your Honor.
All right, very well. Let me identify what I have this morning next to my docket. State of Oregon versus Ronald Thompson, case 25 CR 03118. Do I have Mr. Thompson in the courtroom?
Right here, Your Honor. I can't tell whether I need to stand up for you to see me or what.
You are fine where you are right now. I can see you just fine. And do I have Mr. Fleming this morning?
Yes, good morning, Your Honor. Kyle Fleming for the state of Oregon, OS bar number 135752.
Go ahead and take a seat. Let me tell you what I have this morning to address in the record. I saw the motion to disqualify Judge Bagley filed by Mr. Thompson, and then I also saw the state's motion to limit judicial qualifications. I did have a chance the last couple days to review the file. I took a look at the charging instrument. I looked at the motion filed by Mr. Thompson to disqualify Judge Bagley. I reviewed the state's objections. I looked at the state's motion to limit judicial challenges. I saw Mr. Thompson's objections. So I reviewed everything, and I do not need the parties to parrot everything that's in your filings. I certainly want to give you a chance to argue or highlight what you have filed, but I don't want you to read the paperwork to me. I've already read that. I understand that. I understand the positions, but I'll give you a chance to highlight anything you want to add. Mr. Thompson, do you have anything to add to your motion or your objection?
Well, no, Your Honor. I have been looking at, I got your letter regarding the assignment. And, I got to looking at that, and we've been down this path before where we've had to pursue just exactly what was involved in that assignment. And it seems that it requires an order of assignment or some kind of an assignment from the Chief Justice. And I haven't seen any kind of document like that. Okay. So I guess I'm just wondering how appropriately assigned you've been.
Well, I have been assigned, and I've not received anything in writing, but I have been assigned this case, and I'm assuming that that assignment has been made by either the chief or else something that's been done at the Salem level. That's not a barrier for me to go ahead today and take arguments. So let me ask, sure. Mr. Thompson, did you have anything to add to what you've already filed?
If anything here, we do have a signed order from, I believe, December disqualifying Judge Bagley. So that issue seems to be moot. Okay. Have you seen that order?
Was that in a different case?
I believe it was in this case, actually, and I believe it was signed by Judge Ashby.
You're saying that in this case, Judge Bagley has already been disqualified?
I don't know about that. However, what I would say is that once a judge has been disqualified for bias, for misconduct, as has happened numerous times in the past with Judge Bagley, they can't all of a sudden be unbiased. So my constitutional rights have been violated by Judge Bagley numerous times, and there are numerous judicial complaints filed with the Commissioner for Judicial Fitness and Disability. And once a judge, is identified as being biased, they can't just magically one day decide to not be biased and have any kind of a decision be trustworthy and trusted. And that goes for all of the judges, actually. This has been an ordeal going on for 12, 13 years of judicial misconduct, primarily beginning with a lot of ex parte judges' chambers meetings and other things with the civil attorney in these matters, Mark Reinecke. And that's not speculation. Those are witness things. And as in with Judge Miller, he actually stated in the open court at trial, at the conclusion of a trial, when we spoke late last night, well, you automatically have a biased judge by pre-trial ex parte contact by meetings or whatever. So you can't come back from that kind of thing.
Okay, I think I understand. Mr. Fleming, things to add to your briefing?
Thank you, Your Honor. So I'll just respond to that briefly. First, there is no order disqualifying Judge Bagley in this matter before the court now. There may be an order in some prior matters I've listed quite a number of times in prior civil cases where Mr. Thompson has moved to disqualify various judges in Deschutes County. But in this matter, there is no order disqualifying Judge Bagley. So that issue is still live. I'd also point out the entire structure of ORS 14.210, 14.250, 260, 270
right.
contemplates and requires a motion to disqualify in each individual cause or matter before the court. You cannot disqualify a judge for all time by filing a motion to disqualify in a prior matter. It's simply not contemplated by Oregon law. It is not included in the structure of the statute and put forth by the legislature in that way. So it has to be in each individual action. I'd also point out just specifically on the motion to disqualify Judge Bagley, the affidavit sets forth a belief that Judge Bagley is biased, but sets forth no specific grounds for why she should be disqualified after the initial 2 disqualifications for a belief of bias have been granted. So Mr. Thompson has filed motions under ORS 14.250 to 270 against a number of judges alleging his belief that he can't get a fair and impartial hearing in front of them. I concede that absolutely he can file those for at least 2 judges in the county, but no more than 2. And he has filed now 7, including one for a judge from Crook County who was originally assigned to hear these motions out in county. That's Judge Hillman. So we are well beyond those 2 filings. At this point, the only way he could disqualify any other judges is for the grounds set forth in ORS 14.210, which are very specific. And those grounds include
I'm familiar. I'm familiar with those.
And I will skip over those, Your Honor, so we have those. And so my argument here is essentially on the motion to disqualify Judge Bagley that he has already used up his 2 required challenges. He can't use any more. I do have a citation for the court very briefly. I didn't include in my briefing. I found afterwards. That is Huffstutter v. Lind. That's that's 250 OR 295 from the State Supreme Court in 1968 case. Just a quick quote from the case, the party's purported affidavit of prejudice filed against all 16 circuit judges in Multnomah County was a nullity in view of the statutory provision for disqualifications of 2 judges only. So there's some case law we have supporting that statutory provision. I'd also point the court towards some additional case law, in so in State v. Oval, it's 325 ORAP 538. That's a 2023 case. That statutory motions to disqualify a judge due to a party's subjective belief of bias are strictly held to the procedural limitations the legislature placed on them. So there really is just no argument to go beyond 2 disqualifications. The case law makes that clear. And then turning to the motion to limit.
Give me that citation again, please.
Absolutely, Your Honor. And that is State v. Oval. That's O-V-A-L-L-E. That's 325 ORAP 538. And that's a 2023 case. So turning to the motion to limit judicial disqualifications, the reason I filed that motion is because of what I view as something of an abuse of the disqualification applications that's going on here. Mr. Thompson has made pretty plain in his filings that he intends to achieve what is a de facto change of venue by continuing to file motions to disqualify every judge in Deschutes County. I don't think that's appropriate here.
I object to this comment, by the way, Your Honor. It's completely out of line.
That's just hang tight, Mr. Thompson. I'll get back to you.
If Mr. Thompson wanted a change of venue, he could make that argument directly in a motion. Instead, he's filing motion after motion to disqualify judges without citing the appropriate for-cause grounds to disqualify them. At this point, essentially, I filed that motion because I wanted the court to take that matter up and take a look at each one of these disqualifications, make a ruling about his ability to file future disqualifications, because I have every reason to believe that this conduct will continue. I'd like an order essentially saying that Mr. Thompson is prevented from filing future disqualifications for bias and only can file disqualifications under ORS 14210 for cause for the enumerated reasons in that statute. And at that point, any motions filed for disqualification must have oral argument, because I filed a number of objections. Those objections have been, not heard before the motions are granted. I've asked for previous oral argument on prior objections. They were not heard for prior motions that were granted disqualifying other judges in Deschutes County. At this point, I would just like that order in the record for the court so that this process of disqualifying judges can be brought to a close and we can in fact move forward with litigating the actual merits of this criminal prosecution. And that's it.
But you don't disagree, do you, that he'd have the right to file for cause challenges?
I do not. I do not disagree with that, Your Honor. He would have the right to file under ORS 14210. That's the for cause statute with the enumerated reasons to challenge a judge that are very specific and that require specificity in their pleading and in the affidavits. I would just like an order saying he cannot file challenges claiming impartiality problems or bias problems. Only under the enumerated for cause statute could he file a challenge. And if he files a challenge under those statutes, we should have oral argument on that and a hearing before the court to make a record. Because we've gone so far down the road of judicial disqualifications that we're at the point where we have to have out-of-county judges come and rule on things, even though we have 9 judges here in Deschutes County.
What about his argument that he's entitled to raise challenges under the judicial code as a basis for challenging a judge?
And Your Honor, there's just no support for that in the judicial code. The requirements are statutory and they're set forth in a statutory fashion. I think the case law makes that fairly clear, that the legislature was executing, essentially providing an opportunity for plaintiffs to make these challenges that's not constitutional. It's not based on any equitable right. It's simply the legislature exerting its authority over the judicial branch at that point to give that opportunity. But clearly the legislature's idea in doing this was to limit the ability to do this. I think the plain reading of the statute can be kind of clear here in that the legislature considered, well, some people may have a problem with judges. We'll give them a chance to challenge 2 judges. If they go beyond that, they need one of these enumerated reasons, which really cover much of what the judicial code would have covered as a true conflict of interest. Right. I mean, they're very much the same. So it's not like he doesn't have an opportunity to challenge a true conflict of interest. However, what we have going on here is just Mr. Thompson asserting bias based on a belief that past rulings were unfair to him. A lot of litigants may think that judges are unfair based on their rulings. Those are not grounds to disqualify those judges. At the very least, any claims of that nature should have a hearing and be litigated before the court before they're granted.
Okay, thank you. And Mr. Thompson, I'll give you a chance to respond.
Thank you. Every single motion for disqualification has been for cause. Mr. Fleming very incorrectly states that these have been made due to unfavorable decisions and everything. That's not true. Further, Mr. Fleming seems to be treating this as though he's prosecuting some kind of a crime, like it's a crime to disqualify judges who can't follow the rules, who engage in ex parte communications, of which there has been much. We have judges here who are known to accept $25,000 cash bribes. Where does this kind of thing stop? Mr. Fleming is taking this well beyond this criminal case. He is trying to rope everything into the 12 years of civil litigation and apply the same thing to that and say that everything these judges have been doing, that this stuff should have ended 12 years ago. And here we are because of improper judicial actions outside the courtroom. I also, it's a very big matter in the Constitution that everyone deserves to have their grievances heard before an impartial, just court. And so how do you just get a 2-judge limit on that? And after that's up, then nobody has to be impartial anymore? That makes no sense at all. And it's unacceptable. So I think this motion is out of place entirely.
Okay.
And it's just a stall tactic.
Okay. I think I understand the respective positions of the parties. And again, I have looked over the briefing. I've not read those 2 cases that Mr. Fleming mentioned, but I certainly will. Let me tell you what my plan is so it's clear. I have some motions to deal with in several other cases involving Mr. Thompson and some other parties in which oral argument was not requested. And I've been working on those a little bit, and my plan is to get a letter opinion issued within the next 10 days or so. And I'll include in that letter opinion my ruling on this particular case, the criminal case, State versus Thompson. So I'm not going to issue an oral ruling today. I'm simply going to take the matter under advisement. But I'll do my very best to get something out on all of these cases within about 10 days. I know next week I'm buried in jury trials next week. So I'll try to work on some this weekend and maybe the following weekend, but I'll do my best to get something else out. Mr. Thompson, I can't respond to your first concern about the assignments. I just don't know any more than you do. I'm going to let the state court administrator deal with that. But as of right now, I've heard enough to make some decisions here. So unless there's anything else, Mr. Fleming, anything else from you?
Nothing from the state, Your Honor. Thank you very much.
And Mr. Thompson, anything else this morning?
That's all, all off the top of my head. Thank you very much, Your Honor. I appreciate it.
Very well. I'll get that letter out in about 10 days. Thank you all. Have a good day.
Thank you. You too.
Thank you.
Go off the record. You're welcome. We can terminate the video and go off the record.
Thank you, Your Honor.